Is a sound a piece of intellectual property? Let's take the Hawk Tuah girl as an example.
Hawk Tuah. What is the intellectual asset rights that you can raise from this simple phrase? Is saying something cannot be a form of intellectual property. Let's take the Hawk Tuah girl example. In that case, yes, it is, because you got at least two components there in the trademark domain. You can certainly protect the sound of that, and this is an analogy to that might be the NBC chime, where you say ding ding ding. That is a trademark, a soundbite for NBC. Then you also have the textual component, which can be quite broad, because go back to the NBC analogy again. Anybody looking at NBC would realize that yes, it's a famous brand, a famous mark we're dealing with. So you can protect them both from the audio-visual aspect as well as the text aspect. And in general, as you grow big, you want to cover both because they have their strength. And so in short, you certainly can protect an utterance or a unique sound or even a unique video as a trademark application. Hawk Tuah, let's analyze the situation where you can claim ownership of the term. So what happened is, in that example, the girl just coined a new phrase that was very interesting. And after the fact, it exploded, it became a viral meme. Fortunately, in the trademark domain, it's not the first time you publish this that becomes a problem. It's the first time that you sold a service or a product associated with that. Then that's when you write attach. So she can certainly, talk and coin new phrases or new utterances and apply for it as long as it's been used in commerce. And so because she's the first to utter it, and then when it became popular, she's probably the only one who originated it, she will still be able to retain that right to apply for a trademark, and she can chain that to the date of the first sales with that particular, word or meme whatsoever.
So then, if I understand it, as long as you can prove evidence of you using it before someone else did, like someone else would have to come in and prove they used it to some level of popularity before you did.
Well, the use has to be commercial. So maybe I need to rephrase the question first. So what was the question you were asking?
Could someone, basically the question is like, that girl who said that and it got popular, she can trademark it. But what if someone else said, this is getting popular, I'm going to trademark it before she does?
Let's use Hawk Tuah as an example. A girl coined that phrase by accident and it became viral as a meme. So fortunately, because she found that term was very popular, what happened is that in that case, she can start selling products or services affiliated with that. And then because of that, she can establish a very early date for the trademark application that would predate anybody else that tries to ride on her coattail and try to subsequently create a product with the same name. And so she would have that particular advantage. So yes, if you're the first to pronounce an exciting or a viral phrase, using it as a product as soon as you can, and then apply it for a trademark.
Let's go to some founders get really good at building their personal brand. What aspects of your personal brand can you actually legally protect?
Some founders get very good at building their personal brand, and it's not even necessarily limited to founders. You could be an employee of IBM and build your own brand, right? So what aspect of this can be protected? Certainly your name, your likeliness, the image you have. You can protect against other people aping that image. And certainly if you pick a business name that you use in your personal branding, that can be protected as a trademark as well. I think in today's modern social media, I can think of LinkedIn as an example. You could be an employee of, let's say, NBC as a broadcaster. Obviously, NBC owns the trademark, but you'll notice that a lot of broadcasters, they'll have an app and then their name on it. In that case, they are building their own personal brand in addition to building the company brand they're working for. So you can build both. And in this day and age, it's wise for you to build your own personal brand and promote you over the company. In this day and age, the building of your personal brand is important, Of course, the company that you work for, they want to promote the company brand. But let's take the example of a news broadcaster. Let's say you work for NBC. You'll notice very frequently that the broadcaster would have a Twitter handle underneath, at the bottom of the screen. And that is one easy way of building the brand, because you want viewers to instantly recognize you. You want to build your own brand value, and you want to relate to people. And so in this day and age, it's very interesting that you'll see there's a corporate brand as well as a personal brand. And I know that for founders, often you want to build a personal brand in addition to the corporate brand, because people relate to a human, another person, more than they relate to a company. And so by doing that, you actually are promoting both. That, hey, I'm the subject matter expert this field, and I work for my company. If you want to buy products and if you believe in my values, then you want to go and buy my company's product. So for founders, I think you want to build both personal brand and the startup brand as well. So let's say if you're the founder of a company and you hire this exciting new young star, and she or he now has built up a gigantic following. How do you protect the company from the scenario where most people know the company through that personality? So you can do it in a number of ways. First, if you were diligent and you see this coming early enough, what you could do is create a trademark brand for that person, but it's owned by the company. And then you would request that he or she use that particular brand. So for example, in Twitter, you might have, at Rajiv NBC, for example, something like that. And then you would ask them to use only that branding reference, and you own that brand. Right? That's one way of doing it. The second way, which is, let's say you didn't realize that this is a future star, and let's say you, after a year or two, and they've already built their own loyal following with their personal brand. What you could do is, in the next salary negotiation, you can then ask specifically to either have a license to that personal brand, or you can buy that brand directly outright. And I think if you do this in sufficiently an early phase, that cost might not be prohibitive. But let's say somehow you catch the next rock superstar working for you. If you can buy that particular branding early on, that might become a very valuable component. And that way you prevent that name from shifting to, let's say, another company, and you would lose all of that right. If they created some copyrighted content while as an employee, you absolutely own that. As a CEO, if you hired a rockstar employee, what should you do to protect the intellectual property of your company? So first of all, as an employee of the company, they are obligated to assign all the work that they created on behalf of the company. So that is very easy. Now, the tougher question is, let's say if they built a personal brand and they have millions of followers following them, and they happen to join your company, how could you benefit from that? So you can control this by either having an explicit purchase of the brands that they have created. That's one option. Or you may want to consider using a new brand that they can be affiliated with, and that brand is created and controlled by you. So there are a number of flexible ways where you can handle the situation where you have a rockstar employee and you want to make sure you control that intellectual property in case the employee decides to go for a difference. Of course, I've spoken only about the legal considerations, but when you're dealing with a famous employee, you want to use white glove treatment and make sure that that person, it's a win-win relationship for everyone.
A lot of investors don't consider a real moat to be branding or how a company markets themselves. They think it has to just be a unique piece of software. Can the brand of a company, including their logo, their slogan, how they market themselves, can that create a moat for them? And as you answer that, maybe use, for example, you can't distinguish McDonald's from anyone else, right?
So a lot of companies, the investors don't think that the brand is important. They think of software or maybe your particular engineer design. However, that emphasis is not correct. Trademark can be extremely valuable. So as an example, we can think of Apple, McDonald's, Nike. Those things bring instant memory to people and instant recognition. And that recognition is extremely valuable because it'll take billions of dollars to get that brand awareness. So in short, don't ignore the power of the brand. Protect that with the trademark system.
If you're an investor and you're looking at a potential startup who has a strong brand, but you're saying, brand is not a real moat.
I think I would put it the opposite. I think it's more like the company would think about it. So, you as an investor may want to help the company recognize the power of the brand. Okay. I think most likely the technical founders are going to say, hey, I love my invention, but what's the name, right?
Okay.
So let me see. Well, as an investor, you may come across a company that is so in love with the technology that they ignore the power of the brand. How can you convince them that the branding is just as equally important? So an easy example is to look at Apple, McDonald's, or Nike. Those things are built over the years, and now because of the loyal following, they are worth billions of dollars. And so when you see a founder that is ignoring the brand power, make sure you remind them of the power of Apple and McDonald's and Nike.
Right. Let's continue on this kind of like defensibility aspect. Let's say a company's already been in market and now they're starting to either advance their product or create a new product line. At what point should they now start thinking about legal protection of the new idea? And at what point are they able to actually get legal protection?
So your question is about during the product, the conception to development, at what point should they?
I guess, so assume they're already in the market. Like, let's say it's a software company. They've been around for 3 years, and now they've identified a new market opportunity that's either going to expand the current product or create a second product line.
Let's say your company has a product on the market already, and now you found an additional product line or an extension of that product to generate new revenue. What should you do? Well, we've had such an experience when I was at Invisalign where the initial product was established for adults. And then they found that, hey, instead of the full treatment, they can do that with fewer. Let's say just treat only the front part of the teeth where that is the most visible portion. So that's an example of a new product line, right? A cheaper solution solving only a subset of the teeth that's involved. So what are the factors in creating such a product? And what are the IP planning part of that? So, of course, a patent lawyer would come in and understand the new product as early as possible in the space. Because from there, they can recommend maybe either certainly the technology, the technologies that's involved in creating this new product. That's one. Another is if the product involves another name, another trademark brand, then we can certainly think about trademarking. So in general, those are the two main assets that are considered when you launch a new product. And let me give you yet another example. So when in the early days of the computer era, we were helping Compaq computers, and what they do is they launch a new product every 3 to 6 months. Right. And so they put it in the calendar that, okay, 3 months before a product launch, let's bring in the patent lawyers to understand what needs to be protected. And in that call, what we do is we'll say, okay, what are some of the neat new features that you've come up with in this particular version that you don't want your competitors to be able to copy? One simple example was during the early days, when you turn on your laptop, you would have a little click and when you turn it on. And the next generation product had a device that would basically turn off the speaker when you initially turn them on. And so because of that, there's no click. And so that's a feature that we actually patented. In virtually every new product launch, you are going to have 3 to 4 new features that you would announce. And I think it's useful to let the IP lawyers be aware of those new features, and then we can discuss, is this patentable? And if it is, then we need to collect the information necessary to prepare and file a patent application. Now, also, if you're going to pick a new name for the product, that's when the trademark people would come in and do what is called a clearance search, so that you wouldn't pick a name that somebody else might already be using. And in that case, it's going to be very expensive for you to unwind that and then pick a new name. So I guess my point there is that lawyers come in both defensively and offensively, so that way it ensures a smooth launch of your new product.
Have you ever heard of intent to use legal protection?
Have you ever heard of intent to use trademark applications? Those are used very early on before you ever launch your product to reserve that particular trademark or to protect your brand. So as an example, let's say a name, you know that in 9 months from now, you're going to be launching a new product and you want to name that new product Presario. To ensure that you control that particular name, even though you don't have any actual sales or use of that name yet, you can file what is called an intent to use trademark or ITU mark. In that scenario, all you really need to do as an application is the name of the mark, the services or the product that it's affiliated with that mark, and then the owner. So it's a very sparse amount of information necessary to reserve that name for your future use. So what happened is once you introduce your product, you have now sales, which would be needed for us to show evidence of use. Once you have that sales, you can take that and then convert the intent to use trademark into an actual use mark. And now that is a registered mark. And so by thinking ahead, you can control how the brand is protected at a very early point.
Have you ever heard of the intent to use patent?
Have you ever heard of an intent to use protection for your invention? Well, yes, you can do that. And a version of that in the patent side is called a provisional patent application. So what happened is during your conception of the new product, you probably have a list of the features it's going to do and how you would implement those features. So with that information, you can do a brainstorm and put all that into a provisional patent application. The application can be informal. It doesn't have to be in all the legalese. As long as you have the technical information in that provisional application, now you have reserved the intellectual property right to your product at an early point in time. Now, what happened is a year after you file that, and presumably by then you have developed a fully flushed out product, what you do is you take that provisional application and get the IP lawyers to come in and convert that into a non-provisional application. And then it starts its journey going through the patent office to become an issue patent. So that's how you protect your invention as early as possible.
Let's talk about between two co-founders of a company. How do you if you are both developing a product together, how do you determine, who owns
gets
the
on the
product?
patent?
Yeah.
So let's say you have a situation where multiple people cooperated to come up with a new product or a new service. How do you determine who are the co-inventors of that new invention? Well, in general, as a company, that determination is not so important because you can list, everybody into there, and then as long as they're obligated to assign it to the company, who's listed on the patent, it becomes less relevant, right? So some companies take the policy of we're going to just be inclusive of listing the inventors. Others, they take a more legalistic view of who should be an inventor. And the legal view of who should be an inventor is who has contributed to at least one claim of the patent application. And so if you haven't seen a patent application before, the application has generally three major things. First, it has a textual description of how the invention operates. It has a set of drawings that dovetail with the text to explain how the invention operates. And then at the very end, you're going to have what is called the claim. The claim basically defines the metes and the bound of your invention, very similar to like your property, the description of your property in a deed. So the claims basically outline the things that you think are novel and that no one else should be able to enter that particular space. So generally in an application, we have that claim. And what we do then is once we have the claim drafted, then we says, okay, well, who contributed to this claim? And then we go down that channel for each claim. And then that's how the total list of the inventor would be arrived at. So the correct answer, that's the correct way of determining inventorship. But in many large organizations, many people contributed to the development of a product, and it depends, right? You could overly inclusive and, but as long as the asset is assigned to the company, in the end, it's all irrelevant. So that's the way we select inventorship is based on the claim.
How about the other side now? Let's say you're ready to dissolve a company. What do you do with the assets, like with the intellectual property? Who owns it?
From the investor side, of course, at the end of life, the investor, all they care about is to maximize the recovery of their investment. And at the end of life, pretty much the only thing that's valuable is the intellectual property. Virtually everything else is worthless, right? So what the investors will do is they will try to maximize the value of the patent by selling that to the highest possible bidder. And that's the approach that would be used by investors. Now, as a founder, many founders are in love with what they've created, and they want to keep on holding into that and keep on developing that technology. So the founders would then approach the investors and offer them a small buyout to return back to the investors. As one option is you can propose to the investors, hey, I am interested in continuing on with this venture in a different way. And would you be interested in contributing that into the new venture in exchange for some shares in the new venture? So those are two likely scenarios at end of life for intellectual property. It's either going to be sold to a big company who wants to own that technology, or the founder wants to continue on and create a very attractive offer to the existing shareholder to let them continue on.
Every startup founder thinks about raising capital, but deal terms matter. So what are some of the things to pay attention to in those contracts as you're raising money?
Every founder wants to raise money from investors, but understand when you bring money from the investor, you are now having extra owners in the company. So what are the top 3 considerations in fundraising? First, you want to know what the deal terms are in terms of how much they're going to invest in and how much of the ownership that you're going to have to give up. That, of course, is very important. Second is the connections that they bring to the company. You want investors that are interested in helping you move to the next stage. You don't want investors that just throw money at you and then that's it, they disappear. So you want to look for investors who can help you connect to the next generation of investors. And that would help you succeed. The third point is you want the investors to be excited in your technology, and you want to show your investors that you have reduced the downside risk for them through the use of intellectual property. And you can also explain to the investors that by building up the IP, you actually have increased the valuation of the company in multiple ways. First, IP is an actual assets on the balance sheet. Second, IPs protect the go-to-market strategy, and that enables the company to be more open to their potential customer base in communicating the salient features of the product without fear of being copied. So those are the 3 factors: is to find investors that are going to put in money into your company at great valuation. Number 2 is that they can help your company move along. And number 3 is that they understand and buying into your technology and how that's going to change the world and how that technology is protected.
Let's say you're building an AI product, but you're using OpenAI's language, using their LLM.
Mm-hmm.
Do you have anything that is now, because you're using their intellectual property, do you have your own intellectual property or not?
Let's say you're building a new AI startup, and that AI startup relies in part from technologies such as OpenAI, the large language model, or Perplexity, whatever. do you have any proprietary interests that you can protect and build in your company? And the answer is, of course. Every invention builds on top of some prior inventions. As they say, we all stand on the shoulders of giants, right? So what you should be thinking about is how the, say, OpenAI LLM is used as a part of your solution to increase its value to the end users. So increasingly, we see LLMs are now penetrating every aspects of your life. So for example, you would have an LLM that would help when you go to your doctor and you do your billing. The LLM would be there to help make that process better, easier, and friendlier to the customers, right? So underneath your layers of interface with the providers, you have now a large language technology that helps you move along. And so what you need to focus on in that scenario is how your other processes use the LLM as a component to make life easier for the end user. And so you would treat the LLM as a component, no different than, let's say, is a user interface novel? Well, of course, by now, user interface design is not particularly novel, but it's in the way you use it. So let's say if you have a unique way of tying in the customer user interface with a large language model, and you do it in such a way that is very efficient and improves the performance both for the machine and for the human users, all of those things come in and can be documented in a patent application. So the short answer is yes. Even if you use a commercially available LLM, you do have patentable subject matters that you should consider. So let's say you're building this exciting AI company, and part of that functionality arises from a large language model such as the OpenAI LLM. The question would be, do you have any proprietary technology that you can build on that? And the answer is, of course. Most inventions are built on top of other inventions. We all stand on the shoulder of giants. This is akin to saying the inventor of the bicycle now has proprietary rights over the cars and the plane because they all use wheels. Of course, the wheels are only used as an enabling component of the bicycle, but other people can take that wheel and then build new inventions from that wheel. Similarly, the LLM component that you're using is just another component in that journey that you build of an exciting new product that incorporates the LLM.